highly partisan nature, the hotly contested, politicized campaigns that we're seeing in state Supreme Courts around the country are having significant impacts on what those courts look like.
I'd like to play an ad broadcast in Michigan that targets Bob Young, an incumbent justice on the Michigan High Court. The ad from the Michigan State Democratic Party accuses Young, who is African-American, of being a racist and a sexist.
Who says Justice Bob Young doesn't deserve another 8-year term on the Michigan Supreme Court? Fellow Republican Justice Elizabeth Weaver. That's who. She said Bob Young used the word slut and the N-word in deliberations with other justices. What was Bob Young's response? He blamed Justice Weaver for reporting his racial and sexist slurs. Sorry, Bob. Now we all know. Call Bob Young and tell him we don't need a racist or a sexist on the Michigan Supreme Court.
And here's another ad from Michigan that targets Judge Denise Langford Morris, who is challenging incumbent Justice Bob Young of the Michigan Supreme Court.
Judge Denise Langford Morris has been soft on crime for rappers, lawyers, and child pornographers. For a rapper facing a gun charge while on probation, Langford Morris let him walk free. For a city attorney who crashed while driving 100 with cocaine in his car, Langford Morris gave him probation. And for a special ed teacher convicted of child pornography crimes, just 1 day in jail. Tell Judge Denise Langford Morris, get tough.
That ad was sponsored by Virginia-based group, the Law Enforcement Association of America, which has been linked to the National Rifle Association and the U.S. Chamber of Commerce. What about these ads? Most people, when they go to vote, don't know anything about the judges that are on the ballot. And, of course, the television and newspapers rarely cover the records of these judges. So these ads obviously will have a major impact on how the people at least remember the name of the judge and will associate one thing or another, negative or positive, in terms of how these ads come out.
Well, that's exactly right. And you're absolutely right that candidates are much less well known to the voters in judicial races than they are in a race for Senate or governor or certainly the presidency.
I think unknown.
Well, that's probably accurate. And what happens is these campaigns, these nasty television campaigns, come in at the very last couple of days and weeks of the campaigns and seek to define these judges. This year we saw about $12 million, and that's a conservative estimate, about $12 million spent on TV ads in these judicial races, about $5 million of that, 40% of the total spent in just the last week. So this last-minute barrage of negative attack ads seeks to define these candidates, and they frequently target them. Obviously, the attack on Justice Young there, the Democrats' ad attacks him personally, but most of the time the records of the candidates on crime issues, whether they're tough enough on crime, whether they're soft on crime, are the defining themes of the campaign ads. And often the groups running these ads don't have anything to do with the criminal justice system. So the U.S. Chamber of Commerce, groups like that come in, suggest that candidates are not tough enough on crime when their agenda has nothing to do with criminal justice. It's all about tort reform, business issues, and that sort of thing.
Ohio and Alabama?
Ohio and Alabama also saw clean sweeps by the Republican slate of candidates. In Ohio, the sitting Democratic Chief Justice was ousted by a Republican justice on the court who will now be the Chief Justice. In Alabama, where the Republicans have controlled the Supreme Court for several years now, it was also a clean sweep there.
Is there a reason why more money is pouring in now?
Well, I think there are a number of reasons, but I think the key reason is that special interest groups and political parties have realized, and this is not a lesson they learned this year, but they have realized in the past, that the state Supreme Court set policy, in effect, for the entire state. That's a very powerful body, and if they can control a majority, if they can get 4 votes out of 7 in these state Supreme Courts, they have the potential to make incredibly important sweeping rulings that will affect the entire state. A union official in Ohio, going back now 20 years, said, you know, it's a lot easier to buy 7 votes on the Supreme Court than it is 132 in the legislature. And I think that's what they're realizing. If we can flip 1 seat, if it's 3-3, and we can flip that 4th seat and get a majority on that court, that's going to be an important victory for us. And it's a lot easier than trying to flip the entire legislature.
But what's the solution? It's obviously some reformers favor merit selection of judges across the board. The problem then is, of course, that in merit selection you usually have a less diverse judiciary that, in fact, has been through elections that more African Americans and Hispanics Hispanics and peoples of other minority groups have been able to get on the bench at all. So what's the solution from the perspective of the Brennan Center?
Well, merit solution is certainly one option that states can go to, replacing their competitive, very expensive elections with a merit selection system like Iowa has. It's often difficult, though, to convince voters to amend the Constitution, which is usually what's necessary, to flip from elections to merit. This year, voters in Nevada were asked whether they wanted to switch to a merit selection system, and they said no. But there are many opportunities to reform the system short of that. To address the first problem of these money-saturated, these money-drenched elections, we recommend that states look to public financing of judicial races. So this gets judges out of the business of dialing for dollars, provides campaigns funding to run competitive races, and it's been highly successful, public financing in North Carolina, where it was first adopted for appellate races. Wisconsin just adopted a system of public financing, which will be in effect next year for the first time, in a couple of other states. That's an important first step. It's also, I think, vitally important that states strengthen their disclosure rules so that the parties that are paying, often anonymously, for these harsh campaign attack ads are known to the public. And if you show up in court and you're standing before the judge and you know that the group or the company that you're standing across from has given millions of dollars or thousands of dollars to the judge, you'll know. So disclosure is the second key reform. And then good disqualification rules, I think, is the third crucial item. When judges preside in court and one of the parties who comes in has given significant campaign support to the campaign, that judge should step aside and let another wholly impartial judge hear the case. And unfortunately, in too many states across the country, the individual judge, the judge who's subject to a request to disqualify him or herself, has the last word and is the only one that gets to weigh in on whether or not it's fair to question whether they can be totally impartial.
Adam Skaggs, thank you very much for being with us. Adam Skaggs is with the Brennan Center for Justice at New York University School of Law. We also want to thank Carolyn Jenison, joining us from Iowa, Executive Director of One Iowa. This is Democracy Now!, democracynow.org, The War and Peace Report. When we return, we'll be joined by Florida Democratic Congress member Alan Grayson. He says that President Obama's prescription for the next 2 years, bipartisanship, is what caused many Democrats, including Grayson himself, to lose his job. He was defeated in this week's election. Stay with us.